My name is Teresa Kwong, and I represent the United States. This court should vacate George's probation sentence, probation early at 21 months while this appeal was pending. George's sentence was procedurally unreasonable because the district court relied on clearly erroneous facts to vary downward 19 offense levels to sentence George to 48 months of probation. The court imposed a probation sentence primarily based on its finding that George pulled Miss Doolittle from the police car with force, but that he didn't throw her on the ground. Instead, the court found that she fell because George lost his grip on her. These findings were clearly erroneous because they were inconsistent with the indictment, the evidence that the government presented at trial, George's defense, the jury instructions, and most importantly, the jury's guilty verdict.
Okay, what about the fact that the jury found him, acquitted him on the obstruction, essentially finding that he didn't lie when he said that she fell to the ground on his report?
An acquittal on the 15-19 count tells us nothing about what the jury found. Under United States versus Powell, the Supreme Court said that an acquittal doesn't tell us anything. And I think because of that, we have no idea why the jury acquitted on that count. That acquittal has no relevance to this appeal. What we do know is that the jury convicted on the 242 count. And to convict on the 242 count, the jury had to find that George acted intentionally and voluntarily. Just going back to the evidence that was presented at trial, this actually provides a clear idea of like what the choice was for the jury. At trial, the jury watched a powerful video showing George pulling Miss Doolittle from the police car and throwing her face first on the ground in one fluid motion. It's clear from the video that this was not accidental. He didn't try to break her.
And I've seen the video too. It wasn't just face first on the ground at his feet. She flies several feet in the air, correct?
That is correct. And then there was testimony at the trial, including this video where the government's expert said George threw Miss Doolittle on the ground with so much force that she bounced on the ground and rolled away from him. So this was a very powerful video. And the jury also heard testimony from that expert witness, the law enforcement trainer, and George's supervisor, both who both watched the video and testified that George threw Miss Doolittle on the ground. In his defense, George argued.
Can I ask you? I'm sorry, counsel. Can I ask you a question that I've been sort of wrestling with, and the way you just presented your case made me think of it. So there are two possible errors that the two reasons this finding might have been erroneous. One is that it's contrary to the jury verdict, and one is that it's contrary to the evidence, just manifestly contrary to that video.
Right.
Are those at all related inquiries? When we think about whether it was inconsistent with the jury's verdict, do we sort of take into account that we know the jury watched this same video, so we kind of know what the jury was thinking?
I think they are.
Or are
related.
those entirely separate?
No, I think they are related. That's a very good point, because the case that the government put on and the defense that George put on actually, gave the jury a choice. It was either he acted intentionally, willfully, or he lost his grip on Miss Doolittle. George's attorney actually summarized the choice for the jury in his closing. He told the jury that the question in this case was black and white. Is this a throwdown? He's charged with a slam. Was it a slam or not a slam? Period. Was it a slam? Is this a throwing of a body? Yes or no? The jury instructions presented the same choice to the jury. The instructions charged that to find willfulness, the jury had to find that George acted intentionally and voluntarily with a specific intent to do something that the law forbids. The district court also instructed the jury that the parties had stipulated that this offense resulted in bodily injury. George didn't challenge these jury instructions. So the choice for the jury was either to convict if George acted intentionally, voluntarily, or acquit if it found that George lost his grip. The jury wasn't given any instructions about a third option of isolating the slamming and finding, a partial pulling and falling scenario that the district court had. So implicit in the jury verdict was the jury's finding that George acted intentionally and voluntarily, and its rejection of George's argument that he lost his grip on Miss Doolittle. Indeed, the district court's facts wouldn't have resulted in a guilty verdict here, given the jury instructions and the jury's rejection of George's identical argument.
Therefore, Ms. Kwong,
yes.
if we find that the sentence was procedurally unreasonable, do we have to go to the substantive reasonableness?
You don't have to, but it may be a good idea to do that because what the district court did while this appeal was pending, the district court went ahead and terminated George's probation early. But again, you don't have to.
So on that, then, if we vacate the sentence, is there an argument that we should remand this to a different judge?
We don't have a position on that, but we leave that to the court's discretion.
Can I ask a question bearing on that? Am I understanding right that while this appeal was pending, the district court cut the probation back to 20 months? Did the government brief and argue that, or did the district court do that before the government responded?
It was the latter. George sent a pro se request for early termination to the district court. We were not copied on that letter. And then when the court docketed that letter, within 3 days, the court issued the order granting the early termination. So the government didn't have an opportunity to file a reply.
Okay.
So based on how the district court's findings are inconsistent with all these parts of the case, we urge that the court vacate George's sentence as procedurally unreasonable. George's sentence was also substantively unreasonable because it did not reflect the seriousness of his offense or provide deterrence for other officers to not use unreasonable force. And as I said, with the early termination of probation, his sentence is even more substantively unreasonable today than it was on the day that he was sentenced. First, the district court's erroneous view of George's offense by itself rendered the sentence substantively unreasonable because it permeated the court's consideration of the nature and circumstances of the offense, whether the sentence reflected the seriousness of his crime and the need to avoid unwarranted sentencing disparities. The district court also failed
This was 100% variance.
It is.
You don't see that often, do you?
We don't, especially in this kind of case where the victim was restrained during the unreasonable use of force, and also George caused serious bodily injury to Miss Doolittle. The sentencing guidelines recognize how serious this offense was because it added 5 levels because it resulted in serious bodily injury. It added another 2 levels because she was restrained, and also.
And FLE didn't object to the serious bodily injury in the pre-sentence report, did he?
I think he did actually try to say that it resulted in bodily injury, not serious bodily injury.
I'm sorry, I mean the description of what happened, the factual description.
No, he didn't. George did not object to the description of the relevant offense conduct that the district court, in the PSR, that the district court objected to. I also wanted to say that the district court failed to articulate how a non-custodial sentence here would provide deterrence to other police officers not to use unreasonable force. General deterrence is particularly important in a case like this where there was a substantial downward variance. But even aside from all that.
I'm sorry, counsel, can I ask a question about deterrence? It's another record question. Am I right that this incident came to light because it was reported up by someone else on the force who saw this video? Is that what happened?
It is. So what happened was that George filed his report about this incident, and he apparently need like a supervisor to sign off on it, but he signed off on it himself. And then, but when his captain looked at the report and then looked at the video, he saw a disparity between how the incident was described in the report and what the video showed. So he brought it up to the police chief, and then they referred it for investigation.
Well, I don't know if this falls under deterrence exactly, but ought we take account of the effect of a probation-only sentence and the message it would send on the willingness of other police officers to come forward in the face of abuse like this? I mean, isn't that going to be a deterrent for other officers to come forward if the judge effectively says, like, it just was not a very big deal?
I'm sorry, can you repeat that?
Yeah, should the sentencing calculation consider that if this officer gets this enormous downward variance and a probation-only sentence, other officers, like the captain in this case, are going to be less likely to bother coming forward when they have information like this about potential police abuses?
Well, I think that would be, it would have what, like a chilling effect. Like, why bother to do this if the officer's just going to get probation?
And should
so
that,
I can
is
see
that
that
something? Is that something a sentencing judge can appropriately take account of?
I think it should, just because you're talking about general deterrence of other officers who would commit unreasonable force, and then also other officers who would report on that. So I think that actually would be a valid consideration here.
So let me go back to the question on substantive reasonableness. I assume you would like a finding on that it was substantially unreasonable. I guess in order to send a message to the judge who does a resentencing, if we so find. Is that your point?
I think that would be a good idea here, but we leave it to the court's discretion. It was unusual to have the probation terminated early while our appeal of the sentence was pending. Just getting back to substantive reasonableness, the court's remaining reasons for this sentence just were not sufficiently compelling to justify a 19-level downward variance, because most of the factors he identified were common circumstances and collateral consequences of a felony conviction that you find in virtually almost every 242 case. They're not sufficiently compelling to justify to take this case outside of the heartland of 242 cases. Accordingly, this court should vacate George's sentence because it was substantively unreasonable, because it just ultimately didn't reflect the seriousness of this crime and didn't provide deterrence for other officers. And it was made even more substantively unreasonable with the early probation termination. Unless there are questions, I will reserve the rest of my time for rebuttal.
Do either judge have a question? All right, thank you, Ms. Wong. Mr. Carpenter.
Thank you, Judge Floyd, and may it please the court. Both of the government's arguments in this case, both procedural and substantive, are based on the premise that there is only one permissible view of the evidence, so that the jury could have convicted on count one only if it believed that Mr. George intentionally threw Ms. Doolittle to the ground. But that premise isn't consistent with the jury instructions, the evidence, or the government's own closing arguments in this case. I want to start with the jury instructions because I think they set out what my friend alluded to. She suggested that the instructions didn't permit a third option, but in fact, they very much do. If you look at the second element of the offense of conviction at Joint Appendix page 459, the prosecution was only required to convince the jury that Mr. George, quote, used more force than reasonably necessary under the circumstances. And they further instructed that force is unreasonable or excessive if it is used, quote, for the purpose of punishment or retaliation. Based on these instructions, the jury could have convicted if it believed that he jerked her out of the car more forcefully than necessary, even if he didn't intend to throw her down to the ground. And so when we think about this instruction and we review the evidence in light of it, I think it's important to break the use of force sequence down into
But
its
it's not our role to second guess or to try to divine why the jury convicted on count 1 and acquitted on count 2, is it?
You're exactly right, Judge Thacker. It's not your role to speculate about what the jury most likely thought. But what is important about the acquittal on count 2 is that if there is a view of the facts under which the two jury verdicts can be harmonized, then the district court, in its discretion as fact finder, has the authority to adopt that view of the facts.
And how is 100% variance not unreasonable?
So, Your Honor, that shifts, I think, to obviously the substantive reasonableness question. And I think the key point there is you're only going to reach that issue if you accept the district court's findings that the conduct was accidental. In other words,
Well, not necessarily, counsel. We could just reach it in the alternative. So let me ask you the question like this. Let's assume hypothetically for a minute that this judge could find that the officer, or that the jury could have convicted on the theory that the officer sort of maliciously and excessively yanked this woman out of the car, and then unintentionally, but clearly foreseeably, the result was extremely serious injury to this woman. So he abused his public trust. He used excessive force maliciously to punish someone for being mouthy, and the predictable result is that she undergoes extremely serious injury. Even on that account, how is this sentence not substantively unreasonable? We punish people all the time if they do something intentionally that is likely to result in injury, and it does result in injury.
So, Your Honor, I think that there are a couple of key points I would like to make in response to that question. The first is that an imprisonment sentence is not the only way to signal that an offense is serious. If we look across the spectrum of these cases, police use of force cases, the vast majority of them, even when injuries occur, never get charged. And so the fact that this was not only charged, but resulted in a felony conviction with all of the attendant consequences is an important way to signal the seriousness of this offense as compared to others. The second point I would make is that I think when there is public criticism of police officers who use force and who do not face adequate consequences, we are typically, the public, and as I understand it, is typically comparing what punishment the police officer would receive for this conduct compared to the punishment that an ordinary citizen would receive if they had engaged in similar conduct. Here, if an ordinary citizen had engaged in an assault resulting in this kind of injury, it very likely would have resulted in a state court disposition without a sentence of imprisonment. He was charged.
Counsel, I don't know how the public is comparing things, but I thought we are taking account of the fact that this police officer was a police officer and abused the public trust in committing this crime. I mean, he's not an ordinary person who gets into a bar fight. He's someone who's able to use the coercive power of the state to put this woman in handcuffs, put her in the back of a car, then pick her up and either foreseeably or accidentally use excessive force maliciously in a way that results in her extremely serious injuries. That's not a bar fight.
Your Honor, I agree with that. And I acknowledge that many of us, maybe the members of this panel, might have reached a different conclusion if they had weighed these 3553A factors in the first instance. But
Mr. Carver, where would you put this on the continuum? Is it accidental, reckless, or intentional?
So, Your Honor, I think I would put it where the district court put it, which is that with respect to the first piece of the use of force sequence, when he extracted her from the car, that was clearly deliberate. There is no doubt that he was using force intentionally to jerk her out of the car. But when it comes to the second piece, the slam to the ground, I think the court was correct to find that he was not doing that intentionally, that his result was not to slam her down. That occurred as the result of a slip. And when you accept that as the factual finding, it puts this on the less culpable spectrum of use of force offenses, because the injury is not one that was intended. So it is a different scenario if you have a police officer who is intentionally, deliberately inflicting injury with the intent to harm someone. That is a more serious offense, deserving of more serious punishment than the circumstance here, where the district court found, as a matter of fact, based on a permissible interpretation of the record evidence, that the fall and the injuries were sustained accidentally or recklessly rather than intentionally. So I think that's a key piece of the substantive reasonableness calculus, is the judge reasonably viewed this conduct as on the lesser end of the culpability spectrum.
Well, on the lesser end of the culpability spectrum argument, looking at the Sentencing Commission variances for assault, just basic assault for 2020, the average percent decrease or variance was 35% decrease, with a median decrease in months of 12 months. This was 100% decrease, maybe more if you count this letting him off probation early, if you can have more than 100% decrease, with a variance of, his guidelines were 70 to 87 months. So this is wildly disproportionate to anything that would, or that has happened according to the statistics, to other people convicted of assault. And this goes back to your point of how it's different. It's so serious for him because he was convicted of a federal felony.
So, Your Honor,
does that not change your argument?
No, Your Honor, it doesn't. But I do think it raises a key point, which is that the argument that he was on the lesser end of the culpability spectrum is only one of the reasons that the court provided in explaining. I know.
He also said, the district court also said that another reason was the very high amount of restitution that he was going to have to pay, over $20,000, considering his current financial situation. But then I'm curious, he has a federal public defender. I assume he filled out an affidavit of indigency for that. And yet, in a year and a half, he was able to pay back over $20,000 in restitution, for which the court then gave him early release from probation. You don't have to comment on the affidavit part of that, and the fact that he has a federal public defender. Maybe the government would like to comment on that, but isn't that something we should take into account?
So, Your Honor, I will acknowledge the affidavit part precedes my involvement, and I don't have anything intelligent to say about it, just because I don't know. But the thing that I think your question raises is actually an important point, and this is the second piece, or the second reason that the district court judge gave in support of his variance, is that his post-offense conduct had been exemplary. So while Mr. George lost his job as a police officer and then lost a second job upon conviction, he immediately tried and did succeed in finding additional employment. And so the judge, quite reasonably under 3553A, is entitled to give weight to the fact that rather than sit on his couch, Mr. George got out and worked and earned a living and earned the ability to pay this restitution. So I actually think the fact that he was able to pay the restitution back in 20 months is a factor that very much weighs in his favor, because if the court had imposed a custodial sentence and put him, it would have taken away his ability to earn that money. Ms. Doolittle would not have received her restitution in the timely fashion that she did.
It just seems he could also have paid for his own counsel then as well, rather than have an assistant federal public defender. But that's, I understand, far afield of what we can address today.
It is, Your Honor, and I would acknowledge, I think the key point there to keep in mind is that this proceeding went on for a very long time. So it could well be that at the time he filled out that affidavit, he, I believe, may have been unemployed at that time, and then subsequently began to earn money, at which point the appointment was never revisited by the judge or by the government. But again, so that is the second, I think, key factor that the district court considered that supports a significant downward variance. The third one is that he had, I think it was undisputed, at least in the proceedings below, an unblemished record as a police officer in his time on the force. So he had been serving as a police officer for, I think it was 15 or 17 years, and the government never alleged that he had in the past engaged in any other use of force incidents that had been a problem. He had attained the rank of sergeant and was proffered by his defense counsel, uncontested by the government, that he had an unblemished record. That is a factor that the district court was also permitted to rely on to say that a variance is appropriate, because as we pointed out in the briefing, that makes him an outlier in the from the mine run of excessive force cases, where typically by the time an event like this occurs that involves injury, the police officer has a history of incidents that have gone unaddressed. So the court could rely on that factor as well. And so when you combine the full set of factors together, it is enough to support the variance in our view. I would point out to the court that we can use percentages or levels to describe the variance as particularly large, but another way to look at it is this was a 70-month variance. And in the past 3 months, this court has affirmed variances of 125 months, 111 months, and 69 months in cases going back 3 months.
Wiping out the entire sentence? Are there cases where we have affirmed something where the guidelines called for imprisonment and the district court wiped out the guidelines entirely and gave the defendant probation and then cut the probation time in half too?
So, Your Honor, I don't know of a case that fits that fact pattern exactly, but the point I would emphasize to the court is that this court's substantive reasonableness jurisprudence should not be asymmetrical. It shouldn't be that upward variances that give defendants a great deal more time are subject to light variance and light deference and almost inevitably affirmed, whereas a downward variance that gives a defendant a break from the guidelines range is subject to more rigorous scrutiny. If substantive reasonableness is going to be more searching, it should apply across the board. But this court, for more than a decade since Gall, has engaged in a very deferential review of substantive reasonableness, which is compelled by Gall, saying that the appellate court's role is not to reweigh the 3553A factors. Again, each and every one of you may well have given him significant prison time, but the district court judge here, who had 30 plus years of experience on the bench, was entitled to weigh the factors as he saw fit. Nothing that he did rises to the level that this court should hold it substantive.
What? I guess I do hear what you're saying, but just assume hypothetically that in reading this transcript, I think the district court judge, first of all, gave undue weight to rather unexceptional collateral consequences. He said that because this person, I'm sorry, I shouldn't say this person, because Mr. George couldn't own a weapon, he might as well just be a subject of the government. He's no longer a citizen. I think that gives too much weight to a standard weapons restriction on a felony conviction. He just kept emphasizing these unremarkable collateral consequences of being a felon, and then failed to give any weight at all or any consideration at all to general deterrence. What's going to happen? I get the district court really likes this guy, but what about all the other police officers and whether they will be deterred? And so it's not just that I might hypothetically have come to a different number. It's that I see some real problems with the way the district court thought about this sentence. What do I do about that?
So, Your Honor, I will not say that I agree with those concerns, but if you have them, I think the way to address them is through a procedural rather than a substantive analysis. I think it would be to say too much weight was given to this factor because it is unexceptional. It's a common circumstance in these cases. The court needs to give less weight, send it back to the court to reanalyze. The idea that this court should be sending a message to the district court through some kind of alternative holding on substantive reasonableness, I think is a bad idea for a few reasons.
Well, we did that in Engel, right? Isn't that what we did in Engel? And other courts have done that. They've said that the sentence is procedurally unreasonable, but just, there's no point in everybody spinning their wheels. Let us also say a few words about substantive reasonableness, so the system operates a little more efficiently.
Your Honor, I acknowledge that other courts and perhaps Engel may have taken that kind of approach. I don't think it's a good idea because it does entrench on what is understood to be the discretion of the district court judge in the first instance to weigh the factors. And so I agree that Judge Mullen in this case may well have not been quite as articulate as he should have been in explaining his reasons why he believed that this particular defendant, Mr. George, based on the particular circumstances in his case, is someone who deserves a sentence of probation as opposed to a custodial sentence. I don't think this court should, at this stage, say that there is no possible set of explanations that would justify a probation-only sentence. I do think that Judge Mullen should have an opportunity, if this court disagrees with what he has done, to better explain himself, given that he is the one who sat through this trial, who was able to see Mr. George's testimony and evaluate his credibility in a way that this court wasn't able to do. So I would urge the court to stop with the substance or the procedural reasonableness.
Did there need to be an explanation by the district court for releasing him from probation on June 11th of this year?
Yes, Your Honor. I think I note a couple of things about that. The pro se filing noted two important intervening facts that had occurred. The first is that he had maintained compliance with all of the conditions of his probation for the 20 months that he'd been on release, and the second that he had been able to pay the restitution in full. So those are two intervening circumstances that the court was allowed under 3564 to consider. That statute provides the court with the ability after a year of probation to terminate early if justified by the 3553A factors. And I would note that the government in this case did not file a notice of appeal from that determination. That is a second and subsequent sentencing determination on which the government chose not to appeal. So I do think that is a problem that the government has in this case, is that that determination simply isn't before this court. It hasn't been appealed. So
Counsel, can I bring you back? If you can clarify something for me. You said in response to my sort of hypothetical questions, look, if there's an issue with the explanation, that's like a procedural thing, not a substantive thing, and we should view it that way. And I totally understand what you're saying, and I'm hoping you can help me out here. That makes sense to me, but a bunch of our cases on substantive reasonableness do almost, there's some blending, like they do speak almost in procedural terms, like it's substantively unreasonable because the judge hasn't justified it. There's not an explanation given by the judge that would justify it. And so we shift that over into substantive reasonableness. And as I'm sure you know, some members of our court have sort of raised this issue. Substantive is supposed to be different than procedural. But given that a lot of our case law does put this kind of explanation issue over under substantive reasonableness, you think we could write an opinion saying this explanation, what we have here doesn't justify this sentence, but call that a procedural problem? Yes,
Your Honor, and I agree that this court's precedent in the substantive area hasn't been particularly clear. And I think if the court thinks that Judge Mullen gave undue weight to these factors, as you articulated, Judge Harris, this opinion might be a good opportunity for the court to clarify that that kind of error at sentencing is properly characterized as procedural and remand for that reason. I don't think there is a case that is really clear in terms of making that divide between the types of errors that are procedural versus substantive. I do think that the explanation errors fit more comfortably under a procedural rubric, and I would encourage the court, if it's going to go that way, to use this case as a vehicle to clarify the law in that respect, and to give, again, Judge Mullen an opportunity to explain what I think he didn't articulate as well as he should have in terms of the particular circumstances of Mr. George that would justify a probation-only sentence. Because I acknowledge the court's concerns and the government's argument that some of the things here seem like common circumstances. But I think Judge Mullen really had in mind a much more case-specific, individual-specific analysis.
Thank you, Mr. Carpenter. Ms. Wong, you have some time in reply if you want to use it.
Yes, thank you. I'd like to address the restitution issue first before I get into procedural and substantive unreasonableness. With respect to the payment of the restitution award, that the fact that he paid it doesn't have any effect on whether his original sentence was unreasonable to begin with. And if he had been incarcerated, had he paid his restitution award, he wouldn't have been entitled to early release. Moreover, many courts agreed that compliance with the probation conditions, abiding by law, paying a restitution award, wouldn't justify early termination of probation. All those things are just things that a defendant are expected to do. So if those reasons are not reasons to justify early termination of probation, it can hardly resuscitate an unreasonable sentence. And with respect to why the government didn't file a notice of appeal of the early termination, we didn't think we had to, because the sentence is procedurally and substantively unreasonable. The court can vacate the sentence and remand for resentencing, and that should take care of that. And then with respect to procedural unreasonableness, we would just reiterate that the district court's finding that George lost his grip on ski little was contrary to the weight of the evidence and the jury verdict. And of course, that erroneous facts, also weigh in the substantive reasonable argument as well. And my friend tried to paint George as an outlier defendant in 242 cases, but that's actually not true. And if he's even an outlier in 242 cases, it's that this case is actually distinguished from a good portion of 242 cases because he used unreasonable force on a victim who was restrained, and he caused her so many injuries that she suffered serious bodily injury. So on the whole, we think the sentence doesn't reflect the seriousness of the offense, and it doesn't provide any deterrence to other officers. Unless the court has any questions, we will rest on our briefs.
Does the judge have a question?
Yes.
No, well, thank you both for very good arguments. As you know, we have the custom of coming down and shaking your hand, but we're virtually, so we'll just have to do a high five or a virtual handshake with you. Hopefully, we'll see y'all in Richmond sometime as early as December. Have a nice day.
Thank you.
Thank you.
Thank you.
Okay.
Vasquez versus Garland. Mr. Ahmad, you may proceed.
Good afternoon, Your Honor. May it please the court. I'm here to represent Ana Vasquez in her application for relief. This case has been presented from an appeal from the BIA, and the issues essentially revolve around whether there was ineffectiveness by prior counsel who represented Ms. Vasquez at the merits hearing, as well as represented her at the BIA level, and did a very minimal job in that representation. And there was only a 4-page, very scant brief written to the BIA addressing some very minimal issues. We did raise
Mr. Ahmad, I don't want to tell you how to argue your case, but that's not your problem. The question is jurisdiction. And so can you tell us, talk with us about that? And let me just kind of point you in a certain direction. This was an expedited or a streamlined appeal, which was only heard by one BIA judge. And the only final order in the case is the IJ's judge. So what was contained in the IJ's findings has to do with, one, of credibility, and it's number two, that she offered evidence of corroboration, whether he believed it or not, but it was offered. Is that enough to get you by the jurisdictional argument that there's a lack of corroboration before the BIA?
I do believe it is, Your Honor. First of all, as far as the BIA level goes, we believe that it should have been a much more detailed brief that wasn't submitted. Unfortunately, it was the same attorney that represented her in the underlying case.
Counsel, is that your, I'm sorry, is that your way of agreeing that this ineffective counsel did not in fact exhaust this corroboration question before the BIA?
Exactly, Your Honor. I mean, if this attorney had done the job properly at the IJ level, then he would have addressed it at the BIA, but he was the same attorney. And we do believe that a sense of reasonableness should be taken into account as to why it wasn't addressed. Corroboration wasn't addressed by that attorney at the IJ level, and it wasn't addressed at the BIA level. And it should have been addressed, but given the fact that we look at his brief and the scant argument that he made, I think it was a three-page.
So if the exhaustion requirement wasn't satisfied, how are you here?
Well, we filed the appeal for the petition for review, and our argument is that the attorney who represented the respondent was the same attorney in the underlying case.
Your entire argument is ineffective assistance of counsel. That is your entire argument?
On the jurisdiction front, Your Honor, but we do believe that the case has significant merit once it gets beyond the jurisdiction issue. If she had had a competent attorney that represented her at the BIA level, all these issues would have been raised.
Does our in-bank opinion in Flores help you with your exhaustion argument?
I do believe it does, Your Honor. I mean, it does argue that because she wasn't given proper representation, that this court in bank is allowed to review the case as a whole. And we do believe that that should be given some weight, given the nature of the way she was represented, the limited scope of the testimony that was provided. The attorney didn't even address the affidavit that she had written or cross-examine as to many of the issues. There was also psychological evaluations that were not provided into the IJ that should have been provided. And again, these issues were never raised at the BIA. We do concede that those issues were not raised at the BIA, but given the fact that it was the same attorney, that speaks volumes as to why he didn't raise issues about his own ineffectiveness. We do believe that this court should look at the case in bank and look at the merits of exactly why.
And wasn't the IJ's reason for or justification for requiring corroborative evidence was the IJ's view that the petitioner was inconsistent in her statements, and the IJ was wrong about that, right? She was not inconsistent in her statement that she feared returning to El Salvador, right? That helps you, doesn't it?
It does, Your Honor. We didn't see where the IJ was inconsistent in her testimony. The IJ indicated.
No, not that the IJ was. Okay,
I'm sorry. Ahead. I mean, I meant the petitioner.
Right. So the IJ's perception about that was incorrect, and then when the IJ based his or her perception on an incorrect view of the record, we have an obligation, don't we, to correct that, or at least remand it so that the BIA can have an opportunity to correct it in the first instance.
Exactly. Where the IJ makes a improper finding or errs, because the record clearly shows that she was not inconsistent. We believe this case should be remanded. And the IJ did make a finding that she did not corroborate her testimony. It was inconsistent, but I did not see that in the testimony she had provided. So we do believe.
In fact, the opposite is true. She consistently said she did fear returning to El Salvador, correct?
She did from the very beginning. In a reasonable fear interview, she did also. She even sought psychological help when she arrived here. We believe her testimony has been consistent throughout the process, from the beginning up until the merits hearing.
Counsel, so I just want to make sure. So your position is just sort of a clear IJ error is something we should sort of notice and remand on, even if it was not brought to the attention of the BIA. It was not exhausted, but we should do it anyway.
Yes, in this particular situation.
Okay, and then my second question is, did you argue that in your brief on appeal? Will I find that somewhere in your brief?
In this brief to the Fourth Circuit, yes. Yes, it's argued under the last section, under the ineffectiveness section. So I believe page
back to that.
23.
No, your ineffectiveness section is just sort of a separate, there's an ineffect, but you don't, I'm just looking for an argument that there's sort of an exception to our exhaustion rules. If there's a really obvious mistake, we should just fix that even if it's not exhausted. Is that, I didn't see that you addressed, it doesn't matter. Can I ask, is there a reason why, if you think counsel was ineffective, you didn't file a motion to reopen before the BIA based on ineffectiveness? That's the customary procedure.
Your Honor, that is correct. But the problem we had was that we were brought on as attorneys within the 30-day window to file the petition for review. We did not have access to the record. The client did not have the record with her. We had no way of knowing at that time what the errors were that were made by the IJ or the counsel until we received the whole record. We didn't get the whole record until well into the petition for review process. So
I'll ask your colleague about this.
I'm sorry, Your Honor.
But I think it's customary under those circumstances to seek tolling, equitable tolling of the 30-day deadline, given the ineffective assistanceness, and that the BIA will at least consider that. Is that not right?
It is right if we have some solid ground as to the ineffectiveness. We didn't get to that point until I received the entire record, which was months later after the petition for review was submitted. And that's essentially why it was not raised or a motion to remand or reopen wasn't filed, because by the time we got the record, we were well into the procedure of the petition for review at that point.
Can you, I'm also trying to understand your exhaustion argument. Can you, for me at least, make your exhaustion argument in the context of our Flores decision?
In the context of Flores, essentially, we believe that if a reasonable explanation is not provided, and I think the case we cited is Berry versus Gonzalez, where if there is a reasonable explanation as to why the courts did not, as to why we didn't proceed with Lozado, based on that, we believe that this court has jurisdiction if it believed that there's a reasonable reason why the proper channels weren't followed for ineffectiveness. So, for example, following Lozado, filing a motion to reopen. Based on those grounds, we believe that there is a jurisdictional avenue here to review the case en banc.
Mr. Ahmad, do you have to concede exhaustion in this case based upon what was contained in the IJ's order and the language that he used about corroboration and credibility? My thought process is that the BIA needs to consider what the IJ considered. Is that right?
It is right to the extent that it's raised in the brief. But if the attorney who represented the respondent doesn't raise it at the BIA level, the BIA can rubber stamp it, which is what they did.
Yeah, but I'm not talking about the brief. In these streamlined cases, all they have to do is to file a notice of intent to appeal. They don't even have to file a brief. So if you filed a notice of intent to appeal, and this was a single BIA judge, and the only final order in this case is the IJ's order. Does that not help you out, or does it hurt you? What? Help me out.
I mean, I think it does. I think it does help out, because then we're looking at the IJ's decision, and the IJ's decision, we believe that there was clear errors. There was a cognizable particular social group which was not addressed. The IJ found there was no social group. We believe that it was addressed. The IJ found that her testimony was not credible or contradictory. We believe, again, that it was streamlined and her testimony was in line with what she had said from the very beginning. So based on those arguments, we believe that this entire IJ decision should be overturned, and the case should be viewed as en banc at this point.
Do you have anything further, Mr. Ahmad?
No, Your Honor, that's it. If there are any
Right,
questions on the issues?
The panel does not have any questions, and you have some time in rebuttal. Mr. Pennington.
Thank you, Judge Floyd, and good afternoon. Greg Pennington for the Attorney General. So Petitioner's Counsel has conceded that there was no exhaustion in this case. So the court just, the decision in this case should be simple. The court lacks jurisdiction to review unexhausted arguments. It's held that for well over a decade, that there is no exception for a gross miscarriage of justice. I think that kind of goes to Judge Harris's question earlier, whether there's an exception to the statutory exhaustion requirement. And the court held in Massey that there is no kind of gross miscarriage of justice exception to fix obvious errors that the IJ might have committed when those errors were not brought to the board, to give the board the chance to correct those errors. That's the whole point of exhaustion, is respect for the agency to allow it to work its way through the process and correct any internal errors before getting the judiciary involved. And the brief to the board, as Mr. Ahmad also noticed, was defective. I mean, there was just simply no argument. But the proper course for that is to file a motion to reopen pursuant to matter of Lozada.
Didn't Flores hold that specific arguments subsumed within an issue need not necessarily be raised for the issue to be exhausted? And if so, why does it matter if the petitioner's arguments in her brief to the BIA were conclusory, provided that the overarching issue was raised?
So even under that circumstance, there still has to be some sort of exhaustion, putting the board on notice that I'm raising this argument, even if something might be contained within it as a narrower argument, I'm putting you on notice to give you the chance to answer it. But this court has also held in Corplor, I believe I'm pronouncing that right, that there is no exhaustion by proxy. So you can't say I'm appealing the asylum, but I'm not, and say nothing about withholding of removal or the Convention Against Torture. That doesn't exhaust claims regarding withholding of removal or the Convention Against Torture. So,
well, we don't have, in this circuit, we don't have a case that I'm aware of that says you can't consider a claim within a claim. And so if she raised the asylum issue to the BIA and there's this claim within, why can't we consider that?
Well, because the claim, even if you're operating under where you can consider a claim that's within an exhausted claim. So say I am challenging the immigration judge's finding that my group was not a particular social group, and the immigration judge's finding was on particularity. That might be sufficient to exhaust. But if you look at the brief that was submitted to the board here, there was just nothing said. There was 3 sentences that could be construed as arguments, and I use that term lightly, that said Ms. Vasquez experienced harm that rose to the level of persecution. The immigration judge did not deal with whether she experienced harm that rises to the level of persecution. So that doesn't exhaust anything or anything that could be consumed within that. Her second argument was that the police or the government of El Salvador was unable or unwilling to protect her from this gang member. But the immigration judge didn't make that finding either. So there's nothing that could be subsumed within that. And her final assignment of error was that she was targeted based on her gender. But she never raised gender as a particular social group below. And even if that could be considered to, yes, go ahead, Judge Harris.
Counsel, so I understand what you're saying about the brief, but I thought, and maybe I misunderstood the question, but I thought Judge Floyd's question was, why isn't it enough that at least asylum is exhausted? The brief may not have tagged torture or withholding, but it did say asylum. And so is it possible that just by saying asylum, you've now exhausted any argument that bears on your eligibility for asylum? Or do you think that is just too broad? We have never gone quite that far.
I do not read any of this court's decisions as going that far. That would kind of give to the vice that exhaustion is designed to cure. Is you got to put the board on notice of what the arguments are. You can't just file a notice of appeal and say, I appeal the denial of asylum, and then not file a brief, and then come to this court and say, well, the denial of asylum was erroneous because A, B, C, D, and list all of your assignments of error, because you never really gave the board the opportunity to cure any errors because you didn't put the board on notice of those errors.
And your view is that would be the same exhaustion rules apply in this kind of a summary proceeding or summary appeal, whatever it's called, as they do in a normal appeal?
Yes. I would first note that, petitioner hasn't challenged whether exhaustion was required. So this case would be a bad vehicle to really address that because there hasn't been any arguments really fleshed out. But it would apply because, and I would point the court to the Ninth Circuit's decision that I cited, I think it's Zuru, that streamlining kind of might be influenced based on the arguments presented in the brief. So the regulations on streamlining allow for a streamlined decision in several different scenarios, one of which is where the arguments raised on appeal are so insubstantial as to not warrant a written opinion. So the board might see this 4-page brief that doesn't challenge any of the immigration judge's findings and say, we don't really need to write an opinion here because they haven't challenged anything on appeal. So that might influence.
I want to go back to your statement about about membership in a particular social group. In her challenge to the denial of asylum, there is language that the holding that the respondent did not meet the requirements to show membership in a particular social group is erroneous. I mean, she did raise that before the BIA, didn't she?
You would have to construe her brief liberally.
How liberal do you have to be when the plain English says do not meet the requirements to show membership in a particular social group is erroneous? How much plainer do you have to be?
Well, I think that the brief to the board needs to put the board on notice as to what part. Does the petitioner believe that the immigration judge erred in finding that she wasn't a member of her own proposed group, or that the immigration judge's finding on particularity was erroneous, or a social distinction, or the whole shebang? Is it all bad? The board just has no way to know, and a generalized statement like that should not be sufficient to exhaust a claim in any circuit, much less under this court's jurisprudence that a petitioner must raise every argument before they raise that argument in the Court of Appeals. So I understand what you're saying, but then I would go and say that, okay, even assuming she exhausted the asylum particular social group, she says nothing about nexus in that brief to the board. She says nothing about corroboration in that brief to the board. So both of those, even if we accept that she challenged particular social group and she exhausted this one thing, and we can look at the immigration judge's decision on the cognizability of the social group, she still has not exhausted corroboration, which is dispositive for failure to meet a burden of proof, and she hasn't exhausted nexus, which is also dispositive.
Doesn't Tazi say that we have a responsibility to ensure that unrebutted, legally significant evidence is not arbitrarily ignored by the fact finder? And here the IJ just got things wrong in terms of his or her justification for requiring corroborating evidence, in terms of finding that she was able to avoid the gang for almost 4 years, when in fact she said that she received frequent visits from the gang during those 4 years. There are a number of other things that the IJ just got wrong. Is that there's some obligation to at least remand it for the BIA to consider that in the first instance?
First, I agree, Judge Thacker. There are several things in this immigration judge's decision that I would not say are correct, or I would not stand here and defend. But there is a proper recourse for Ms. Vasquez, and it's a motion to reopen to raise claims of ineffective assistance to counsel. The statutory time probably has passed. So she has, as a matter of right, so exhaustion under 1252 D1. And now I understand Mr. Ahmad's argument that he did not have the record and this petition was already ongoing. But I would point the court to the Supreme Court's decision in Stone v. INS, which recognized that there are two separate paths. There's the petition for review of the final order of removal, whereas the court can start reviewing the final order of removal, and then the non-citizen can also file a motion to reopen or a motion to reconsider and let that play out before the agency. And then the statute explicitly contemplates the court combining those two petitions for review into one. So he wasn't prevented, or she wasn't prevented from filing a motion to reopen. She could have filed the motion to reopen, requested an extension for a briefing on the motion to reopen until she had the record. I believe the record was filed within 40 days of filing of the petition for review, which was filed within 30 days of the board's decision. I would imagine that still would have left time to file a motion to reopen. But even
Why doesn't the government have some interest in the immigration courts getting the facts right before they make these decisions? Why isn't the government interested in correcting the record that even it admits the IJ was incorrect on here, on some of the facts?
Right. So I agree that some of the facts are, and I even mentioned some of them in my brief, that some of the facts are just wrong. But the board's decision.
Go ahead.
The board's decision in this case should be the final order of removal. And when the board uses the streamlining process, it doesn't imply, and the regulation explicitly provides, that it's not approving of the reasoning of the immigration judge or everything in the immigration judge's decision. It's just saying that.
I understand, but if this, so you work for the Department of Justice, so I don't understand why the Department of Justice isn't, like the petitioner, interested in making sure that the court gets the facts straight before it makes a final decision. You don't want to, if this was a criminal case, certainly the government wouldn't just stand there and let the court get the facts wrong and then face a conviction or a sentence on incorrect facts, would it?
No, and I agree. The goal is to seek justice, but here the outcome is correct, despite the factual misfindings of the immigration judge. The ultimate outcome is correct, and I've set forth the reasons in my brief why that should be. So
how do we know? I thought you said the BIA, the petitioner's brief was so conclusory that it didn't raise anything. How did the BIA, was the BIA aware of all these incorrect facts since the brief was so conclusory?
I don't know how much the BIA would read into a record when it's faced with a brief like that. And we don't know what part, because the BIA, when it issues a streamlined decision, says it agrees with the ultimate outcome. But we don't know what in particular it agreed with. Did it agree with the corroboration finding? Because, petitioner does not challenge that even here, that she failed to corroborate with any letters from her husband who she lived with in Mexico, or her parents who she said this gang member came by her house after she left.
And the government agrees that the basis for the corroboration finding was the IJ was incorrect, right?
No,
when the
statute.
When the IJ found justification for the corroboration, requiring corroboration, the IJ found that justification based on the fact that the IJ had an incorrect understanding of the record and thought that she had been inconsistent in expressing her fear of returning to El Salvador. And that wasn't accurate. And the government knows that that is not accurate. It's in black and white.
She was inconsistent. She was inconsistent in why she said or what happened to her. She was consistent in saying that she feared going back to El Salvador, but she was inconsistent saying what happened to her in El Salvador and what formed the basis of that fear. So there were several statements she made.
Well, but counsel, it doesn't really matter, right? Because you have conceded that the IJ erred in requiring corroboration without first making the reasonable availability finding. So one way or another, I think we all agree, this is in your brief, the IJ got it wrong in requiring corroboration. We'll put to one side the reading of the record, but she didn't do the reasonable availability inquiry under Wambura, so that's wrong. I thought your argument was, forget corroboration, maybe all of that is wrong. There's still no particular social group on this record. Like, there's just no way around that. So the outcome is correct, no matter what you think of corroboration. There are two alternative holdings here, and I thought the one that you were defending on the merits was the particular social group one. No?
Well, I'm defending all of them on the merits. I mean, the court should not get past subject matter jurisdiction to review any of these. That's the government's first position. The court simply lacks jurisdiction. She still has an avenue.
I know, but we're in the part of the argument now where you are arguing, look, anyway, they got this one ultimately right. So I just wanted to sort of press on what is your ground for saying that, given that I think I read your brief correctly, that you were conceding at least the procedural error in requiring corroboration without first finding that it was reasonably available.
That's correct, Judge Harris. So
okay.
I would still defend the corroboration based simply on the failure to challenge it within the court. We still have to have, party presentation of errors. So, but
I'm sorry, the failure to present it before this court.
Yes, Judge Harris.
I appreciate Judge Harris's question and trying to get you beyond corroboration, because I need some help understanding your argument beyond the corroboration, because I don't agree with your argument on corroboration. So she's trying to help you. This is one of those examples, I think, well, maybe not. She's trying to help me, perhaps.
And I shall move on at your recommendation. So yes, so the immigration judge made several findings in addition to corroboration. One of them is that she has not established a viable particular social group for three separate reasons. First, that she didn't show she was a member of her own particular social group. It wasn't immutable for her because she didn't demonstrate that she was controlled or treated by property by this gang member. And there isn't record evidence to compel a different finding. According to her testimony and declaration, she was the unfortunate victim of this rape where she was drugged. I don't know the circumstances, but they gave her a Coke that was drugged. She was raped. She didn't remember it. She doesn't know who did it for sure. She woke up. And then the next incident, I mean, she makes this generalized statement that they would harass her, but she doesn't say what that means. But the next incident didn't happen until 4 years later. So over those 4 years, she wasn't even a member of her own group of women who are treated as property and controlled.
I mean, she did actually give several examples of how they harassed her, though. I mean, I could go through them. You said she didn't, but she did. She said they would just pass by in front of me all the time, and they would laugh and say, "You liked what we did to you." Frequently asked her if she was going to surrender herself to them, demanded that she turn herself over to them, they asked who was the father of my son, that sort of thing. Visit her frequently. So she did give several examples of how they harassed her.
That is correct. But whether that meets what would be a controlling or treated as property, I think the reasonable minds could differ.
I understand that argument. I was just responding to your statement that she didn't give any examples of how she was harassed. She did give several.
She did in her statement. I do recall that. And the second reason was particularity. She didn't set forth a group with discrete boundaries, so we don't know who is in and who is out. her group is women who are treated as property and controlled by men. We don't know, and petitioner doesn't offer what it means to be treated as property and controlled by men. And finally, social distinction, which requires evidence on country conditions. And I see my time's up. I didn't get to nexus or the Convention Against Torture claim, but both of those two are supported by substantial evidence. We would first ask the court to dismiss the petition for review for lack of jurisdiction for failure to exhaust, or in the alternative, to deny it. Thank you.
Thank you, Mr. Ahmad. I'm sorry, Mr. Ahmad, you have some time in rebuttal.
Thank you, Your Honor. I did want to address some of the issues raised by counsel. I think Judge Floyd asked several questions about what was in the BIA brief that was submitted by her attorney. Looking over that brief, obviously they're not the best of arguments, but as the court mentioned, she does, on page 2 of the brief, it does say the judge erred as a matter of law as far as credibility. Whether it's established or not, or discussed in detail, that is not there. On page 3, the argument for asylum is made. On page 4, an applicant and a membership in a particular social group must establish. Now, did the attorney fulfill this and go in more detail? Certainly that is not there. But these issues are raised. Now, the question is, once an issue of asylum is raised or an issue of membership in a particular social group, we believe that that falls under the umbrella of whether she met the criteria for asylum or withholding of removal. And I believe if the attorney has raised those issues, then they should be addressed at this point. Concerning the...
Wait, so counsel, just so I understand, so your view is that if the brief says asylum, it's up to the BIA to sort of independently figure out whether the IJ got anything wrong that touches on asylum. It doesn't have to be any more specific than that. I definitely take your point about, look, she said particular social group. That was enough to put the BIA on notice. Bear down on what the IJ did with respect to particular social group. But your view is that wasn't required. Same answer if the brief had said one word, asylum. If the brief says asylum, BIA is on notice, you need to check every single component of the ruling on asylum.
I do believe so. I do believe that
do we have any case that says that the word asylum or alternatively withholding or I guess torture is sufficient to incorporate, to subsume every possible argument that could be raised under one of those, that it's enough to say the form of relief you want? What if you just say removal? I'm not removable. Like, what are we supposed to do? And I guess one of the reasons I'm asking is because, the similar rules apply on appellate review of district court cases, and I'm suddenly wondering if somebody says, my sentence is not legal, like, am I now as an appellate judge supposed to figure out any possible ground on which a sentence might be illegal? Is it enough that they said sentence?
No, Your Honor, no, Your Honor. I mean, certainly it has to be more than just a word or a phrase. In this situation, he does talk about that she had established well-founded fear, she'd established corroboration. There was some arguments made, so it wasn't just the word asylum.
Okay.
I don't believe.
So you're not saying that that it is enough to say the form of relief. You're saying that more was said here. I really am just trying to figure out what is your argument.
Certainly, more was said, and I believe it is enough to open those areas. He didn't just say the word asylum. He talked about that she didn't have a well-founded fear. She didn't belong to a social group.
Okay, can I ask you a question about the particular social group? This is the part that confuses me. So, and I understand, just hypothetically now, we're over on the merits. So, as I understand it, the petitioner is not arguing anymore that rape victims is a particular social group. And this was conceded before the immigration judge because it's circular. You're sort of defining the particular social group with reference to the act of persecution, the rape. But what I don't understand is how women treated as property and controlled by men is any different the way it's being presented here, because her argument is, I'm part of a social group of women treated as property and controlled by men because they have been raped. That is why I am treated as property and controlled by men. And so I don't see how it's not circular in the same way. It still boils down to it's your status as a rape victim that is the source of your persecution.
Your Honor, I
Can you
believe in
help-
the situation, it went beyond just the fact that she was raped. She was raped. She had a child who is now the child of a gang member. And on numerous occasions, she was harassed by the same group and threatened that you're one of us or you're a girl that belongs to us. Even when she went
Because
to
she had been raped. I mean, what she says is because I was raped, they harassed me and treated me as their property.
because she was raped and also because she
Right.
had a child as a result of the rape.
As a result of the rape, right? So I guess I'm having trouble distinguishing this from the first category, which is just women who are rape victims, women who are raped by the gang. And I know I sound very callous in talking about this, and I sort of apologize for that, but I am looking for an answer as to why these two particular social groups aren't basically the same thing.
Yes, I think the reason is because as a individual who's harassed over time, over a 4-year period, even after 4 years, in 2014, a knife was held to her and again told her that this is what's going to happen to you if you don't do what we say. So this continued action wasn't just a one-time incident. It went over 4 years, and as the other judge mentioned, there was harassment throughout that 4-year period. So she was known as property. And I believe the information we provided on evidence, I don't have the exact record pages, but it does talk about how women are treated as property who have been threatened by gangs or raped by gang members. And the history after the rape is what makes us different than just an individual who's a rape victim. It's their treatment for the next 4 years and the eventual culmination of the incident involving a knife to the throat and they're going to cut her son's head off. This is not a random incident. She's part of a group of women that are treated as property belonging to this gang of individuals and was raped by one of those gang members. And I think that's where the difference is between her and just women who are raped by or victims of rape.
All right, anything further? All right,
That's
thank you, gentlemen, for your,
Thank you so much.
through, okay, thank you very much for your arguments today, and as you know, our custom is to come down and shake your hands and greet you after oral arguments when we're in Richmond, but unfortunately it's virtual and we can't do that, so we still thank you very much, and you can accept this as a virtual handshake.
Thank you.
Have a good day.
Thank you.
This is Gonzalez v. Garland. Mr. Winograd, did I pronounce that correctly? Winograd?
Your Honor.
All right, thank you. I apologize. You may proceed.
Thank you, Judge Floyd, and may it please the court. The primary question in this case is whether immigration judges and the Board of Immigration Appeals have the general power to terminate proceedings. The court should hold that they do have that power and that the Attorney General erred in matter of SOG by holding that they do not have that. IJs have the general power to terminate proceedings under 8 CFR 1003.10b and 1003.1D12, the same broadly worded regulations on which this court relied in Romero v. Barr and in Jimenez Rodriguez versus Garland. And even if the court finds those regulations ambiguous, the matter of SOG would not be entitled to any deference because it did not interpret the regulations in question and because the Attorney General did not solicit adversarial briefing from the parties. Unless the court prefers otherwise, I will first address the termination issue before addressing the other issues in this case. Now, at the outset, I would
Counsel, I'm sorry. I'm so sorry. I don't prefer otherwise. I do want you to start with the termination issue, but I do have sort of a threshold question about how your arguments fit together. If hypothetically you win on your first issue, you would like us then to hold that IJs have general authority to terminate and then remand to the agency to consider whether they should exercise that authority based on DACA status, right? All right.
Yes.
If we do that, do you still want us to consider your other argument based on DACA status that also do you also want us to remand so that the agency can consider whether it should administratively close these proceedings based on DACA status, or are you presenting those more as alternative arguments?
No, they're not alternatives, Your Honor, because in the event that the request for termination was denied, then my client would like to make a request for administrative closure. And if that was denied, he would like to pursue his application for cancellation.
Thank you. That's all. Thank you very much. Sorry to interrupt.
So just at the outset, I would like to address what we believe is and is not the precise question before the court. The question is not when IJs and the board should terminate proceedings as a general matter. The question is simply whether they can terminate proceedings as a general matter. And to answer that question, the court need only consider why it is that IJs and the board can terminate proceedings when DHS fails to sustain the charges of removability. Contrary to what the Attorney General claims, there is no regulation that specifically authorizes them to terminate proceedings when DHS fails to sustain the charges. So that authority must necessarily come from 1003.10b and 1003.1d12, which authorize them to take, quote, any action consistent with their authorities that is appropriate and necessary for the disposition of the case. If those regulations did not confer the general power to terminate proceedings, then IJs and the board would be unable to do so even when DHS failed to sustain. And matter of SOG implicitly acknowledged as much by holding that IJs may terminate proceedings either when authorized to do so by regulation or when DHS fails to sustain the charges. But that holding was self-contradictory because if IJs can only exercise powers delegated to them by regulation, then by definition, they cannot exercise any additional powers not delegated to them by regulation. And in a footnote, the Attorney General argues that a different regulation, 8 CFR 1240.12c, provides the specific authority to terminate proceedings when DHS fails to sustain the charges. But that regulation makes no reference to DHS's ability to sustain the charges. It merely requires IJs to issue an order at the conclusion of the proceedings that either directs the alien's removal from the United States or the termination of the proceedings or other such disposition of the case as may be appropriate. So if anything—
Mr. Winograd,
Yes.
Let me ask you this. Do you believe that the word any action both includes explicit and implicit authority to do something with the case, such as close it?
Absolutely, Your Honor. And I believe this court held as much in the Romero v. Barr case involving administrative closure. Of course, the regulations on which we rely don't specifically reference administrative closure, but the court found that they imply it. With respect to section 1240.12c, I was saying that regulation actually supports our argument because it presupposes that IJs have the general power to terminate proceedings. And even if section 1240.12c meant what the Attorney General claims it means, the regulation only applies to IJs. It does not apply to the BIA. So under the Attorney General's reading, the BIA could not terminate proceedings even when DHS failed to sustain the charge. So the upshot, Your Honors, is that the very reason that IJs and the board can terminate proceedings when DHS fails to sustain the charges is that they possess the general authority to terminate proceedings under section 1003.10b and 1003.1d12. If IJs and the board if IJs and the board possess the general authority to terminate proceedings, then whether termination is warranted must be decided on a case-by-case basis, subject, of course, to any future limitations set forth in a precedential decision from either the Attorney General or the board itself. Now, one argument that the Attorney General did not directly make, but which the court might independently consider, is that it is always appropriate and necessary to terminate proceedings when DHS fails to sustain the charges of removability, but that it is never appropriate and necessary to do so when the charges have been upheld. But neither part of that argument would be correct, because just as termination is not required when DHS fails to sustain the charges, nor is it prohibited when the charges have been sustained. Terminating proceedings is a remedy, not a right. And while termination is typically the only possible remedy when DHS fails to sustain the charges, there are at least 2 circumstances in which IJs and the board could reasonably decline to terminate proceedings. The first is when there are additional grounds of removability that DHS failed to lodge in the original charging document. In that scenario, an IJ may elect to continue the proceedings, or the board might decide to remain on the record to give DHS a chance to lodge an additional ground of removability. A second scenario is when an alien has been convicted of a criminal offense that could make him subject to a ground of removability, but the conviction is not yet final for immigration purposes because it is still on direct appeal. In that scenario, an IJ or the board might administratively close rather than terminate the proceedings until the alien's criminal appeal has been resolved. But at the same time, just as termination is not always warranted when DHS fails to sustain the charges, it may be warranted even when DHS has sustained the charges. For reasons we explain on page 32 of our opening brief, it is possible under the immigration laws for an alien to simultaneously be removable from the United States and possess lawful immigration status. For example, aliens like my client who crossed the border illegally are removable under 8 U.S.C. 1182 A6A1 for being present in the United States without being admitted. Now, under the INA, aliens are only deemed to have been admitted if they were authorized to enter the country through a port of entry. Aliens are not deemed to have been admitted if they acquire legal status once they are already inside the United States. So aliens who entered the country illegally technically remain removable, even if they are granted asylum or some other status outside of removal proceedings that allow them to lawfully remain in the United States. And in that scenario, it would certainly be reasonable for an IJ to terminate the proceedings because it would make little sense to order the removal of an alien with lawful immigration status. Termination could also be warranted for aliens who are removable, but who could easily obtain permanent residency from USCIS if they were not in removal proceedings. For example, take an alien who was placed in removal proceedings for overstaying his visa, but who has a U.S. citizen spouse, one or more U.S. citizen children, and no criminal record or adverse discretionary factors of any kind. Such an alien would be granted permanent residency in a heartbeat, either by an IJ or by USCIS. But while it could take months for their application to be approved by USCIS, it could take years for them to receive a hearing in immigration court. So in cases like that, we believe it could also be appropriate for an IJ to terminate proceedings without prejudice, of course, so that the alien could seek permanent residency directly with USCIS. But again, the court need not and should not opine on whether the termination of proceedings would be appropriate in this or any other case. If the court holds that IJs and the board have the general power to terminate proceedings, it should allow the agency to determine in the first instance when termination is appropriate and necessary. The Attorney General's primary argument seems to be that it would intrude on DHS's prosecutorial authority to allow IJs to terminate proceedings against aliens when they remain subject to the charges of removability. But we believe that argument is misplaced for three reasons. First, and we think it should go without saying, that IJs would use this power quite sparingly. IJs are employees of the Attorney General who do not enjoy life tenure. So the idea that they would start terminating proceedings en masse is rather far-fetched. And even if that were to happen, DHS would have a right of appeal to the board, and the board reviews discretionary determinations de novo. And even if the board somehow ruled against DHS, DHS could then certify the case to the Attorney General himself. So as a practical matter, any intrusion on DHS's prosecutorial authority would be rather slight. Second, DHS itself has multiple agencies that sometimes work at cross purposes. As I previously mentioned, USCIS may confer asylum or other legal status on an alien that ICE is actively prosecuting in immigration. And when DHS is itself sending mixed messages about whether an alien should be allowed to remain in the country, there's no principled reason why IJs and the board should have to defer to ICE's position rather than USCIS's. And then finally, terminating proceedings over DHS's objection does not raise any separation of powers concerns because DHS and DOJ are both part of the executive branch. In fact, once DHS files a charging document with the immigration court, it is no longer able to unilaterally dismiss the case. If it wants to dismiss the case, DHS must seek leave to do so from the IJ or from the board. And if IJs and the board are not, yes, you're right.
Sorry, I had a question about this, which is there, in thinking about this argument, impermissible interference with DHS's enforcement authority, is there any sort of practical distinction between an IJ terminating a hearing and an IJ indefinitely suspending a hearing? Or I'm trying to figure out why this hasn't already effectively been decided by Romero, because the AG said the exact same thing in Castro Tunk, whatever it was called. The AG decision on administrative closing said we can't allow these indefinite suspensions because that would impermissibly interfere with DHS's enforcement authority. And we were already past that in Romero. So is there anything sort of practically different between indefinitely suspending and actually terminating a proceeding for these purposes? Is there any way to distinguish Romero?
Yes, Your Honor. Well, when an IJ or the board terminates proceedings, that, of course, is the end of the proceeding. And if DHS wants to, again, attempt to remove the alien from the United States, they would have to file a new charging document with the immigration court. By contrast, when a case is administratively closed, it is effectively suspended, held in abeyance. And if either
I understand the formal difference, but I also understand that the AG said in the original opinion, it doesn't make any practical difference because once these things are closed, they're done. They don't come back. It's over. And we held in Romero, it doesn't matter. IJs can still close these proceedings over the AG's objection that it would interfere unduly with DHS's enforcement authority. So I'm just trying to figure out whether, practically speaking, it makes any difference which one we're talking about for purposes of this argument.
Sure. I think, candidly, it is more of a legal difference than a practical difference. Although, of course, an alien who is in removal proceedings, even proceedings that are administratively closed, does have the weight, so to speak, of those removal proceedings.
I understand why it makes a difference for the petitioner, 100%. I'm just trying, I'll let it drop. I'm just trying to figure out whether it makes a difference for DHS's potential interference with DHS's enforcement authority. But okay.
Well, I would say also, since termination, the termination we're asking for would be without prejudice, of course, DHS could always file a new charge in the future. So just the point that I was making about the fact that IJs and the board don't have to grant a motion to dismiss from DHS, we believe if they're not required to do so, if they're not required to dismiss proceedings against aliens whom DHS no longer wishes to prosecute, then there is no principled reason why they can't terminate proceedings against aliens that DHS still wishes to prosecute. Now, if the court finds it unclear, yes, sir.
Oh, no, before we get there, let me ask you one question. So the way I am thinking about this problem is like, look, we already read this regulation. According to its plain terms in Romero, we said it would allow an IJ generally to administratively close a proceeding, notwithstanding the fact that as a practical matter, that pretty much ends it. And so I'm trying to figure out, is there something different about termination that would mean that Romero doesn't apply here? And the only thing I can think of is that in Romero, we did sort of at least cite the long administrative practice of having IJs do these administrative closures with some BIA approval. And we don't have that here. So does that matter?
I don't believe so, Your Honor, because I think you only look at agency precedent if you find the regulations ambiguous. Okay. If the text of the regulation is clear, then under our or Chevron, that is really the end of it. And we think the text of the regulations are clear, and that is especially so in light of this court's decisions in Romero and in Jimenez Rodriguez. I see my time is up, so I will, if not, there any more
questions. Judges have any questions? You have some time in rebuttal. Yes.
Can I just I'm so sorry, just the
sure.
Structure of the argument thing is, if assuming hypothetically and without, if you were to prevail before us on your arguments about DACA status, and we were remanding for the agency to consider whether this proceeding should be either terminated or closed, does that mean we do not get to your alternative arguments about cancellation of removal and the continuance and the motion to reopen?
I believe even then the court should reach those arguments because if the court doesn't have to, of course, but if the request for both termination and administrative closure were denied on remand, then I think we would be back in the same position.
It'd be a little weird though, but the remedy you want us to give you on those second set of claims is you want us to remand for the IJ to have a hearing on cancellation. But if you've prevailed on your first arguments, there's at least arguably no proceeding to remand it for. It would have to be conditional?
Well, that would be our alternative argument if on remand, the request for termination and administrative closure were both denied. Then as an alternative to termination or administrative closure, my client would like an opportunity to seek cancellation of removal. But we are relatively optimistic that one of the two remedies would be granted if the court were to rule in our favor on the termination and or administrative closure issue. And of course, if the court does not want to reach those issues as a matter of judicial economy, that is of course the point.
All right, thank you, Mr.
Thank you.
Winograd. And you have some time to reply. You pronounce it as Bayram?
Yes, that's correct.
Okay, thank you. You may proceed.
May it please the court, I am Sarah Byram, appearing on behalf of Merrick B. Garland, the United States Attorney General. This case presents 4 issues. The most important, of course, is this termination issue. Here on termination, petitioner states that there is no, in his brief, he states that there is no principled reason why immigration judges cannot terminate proceedings against an alien when DHS wishes to prosecute. Before this court, he has cabined that as a general power to terminate. But in essence, what he's really asking for is to give immigration judges the discretionary authority to terminate removal proceedings as they see fit. But there are at least two principal reasons for why this cannot be the case. One, because we have controlling statutory authority and regulations, which the Attorney General relied on, that set out when termination is necessary, when it's required. Statutory authority sets out that immigration judges shall conduct proceedings for determining removability. So there are regulations, there are statutes that speak to this. And second, and more importantly, is for over 50 years, the agency, combined with judicial decisions of 3 circuits, have long held that immigration judges do not have this discretionary authority to just terminate as they see fit. He ignores this precedent in his argument. He's largely ignored it in his brief. But it starts in 1971, continues on through multiple administrations. And of course, you have the 9th, 5th, and the circuit, so weighing in. So on this specific issue, on whether or not immigration judges have this general discretionary authority to just terminate when they would like, regardless of circumstances, regardless of if the alien is actually removable, what have you, there is decades of agency precedent on that, judicial precedent, and that is something that when the Attorney General promulgated SOG, this was just a continuation of that long-standing interpretation that discretionary authority to terminate is not something that is available. Now, there's no dispute that judges have an inherent authority to terminate, but that authority is cabined by the statutory authority, the regulatory authority. They are creatures of statute. They derive their authority.
In your view, what impact did the AG's July of this year decision in Cruz Valdez have on the SOG matter?
Really none, because Cruz Valdez goes to administrative closure. And what we're talking about here is termination. This also goes to Judge Harris's question. Termination and administrative closure are 2 different postures. We have decades of agency precedent, judicial precedent on termination. It's very different from administrative closure. And petitioner weaves in the regulations and tries to build off of what happened with Romero, Castro-Tum, Cruz, and administrative closure, but we're talking about something different here.
Okay, counsel, can I just stop you? So the very first, I don't even know what you call these in these AG opinions, but like header number 1 says that consistent with matter of Castro-Tum, judges have no inherent authority to terminate or dismiss removal proceedings. And like, it just seems not fair to suggest that the withdrawal of matter of Castro-Tum, which literally like the first the third word of this opinion is the matter of Castro-Tum, that the withdrawal of that opinion would have no bearing whatsoever on this question. The agency obviously thinks of these, yes, formally distinct, but very, very similar and overlapping issues, which is why the first words out of the agency's mouth are, we're relying on matter of Castro-Tum to decide this issue.
With due respect, there are some references to Castro-Tum, but the holdings of what the Attorney General said here go to termination, and they are very different concepts. Just to take a step back, termination is specifically authorized by the INA. There's regulations, there's statutes. There's a plethora of judicial precedent on termination. When you terminate a case, it disposes of it entirely. It kills the case, right? And it could prevent the Department of Homeland Security from bringing a new case or new charges depending on how it was that it was terminated. And it obviously implicates, a jurisdictional scheme, but termination is a very different procedure. There is statute, there is regulation, there is judicial precedent talking about it. By contrast, administrative closure just essentially takes the case off the active docket, but it still allows for the continued prosecution of that case at some point. It still allows for DHS to pursue a final order, which of course they have the right to do, and particularly where the circumstances are that petitioner is removable, like here where he conceded his removability. And with administrative closure, you still preserve all those things. There is also nothing in the INA or the regulations that specifically authorize administrative closure, which is different from termination. And so,
well, but that's not what, excuse me, counsel, that's not what the Attorney General said in matter of Castro-Tum. He made the same argument you're making here. He said, look, the regulations specifically provide for continuances. This is just another form of continuance. So the specific regulatory authorization for continuances means there can't also be a general broad authorization for these indefinite suspensions. So the exact same argument was raised there, that the specific, if there's some specific regulation that touches on it, you can't have this general authority. And we rejected that in Romero. So I don't see that as a distinction we could rely on here.
Well, with all due respect, if nothing else, the distinction is that termination specifically disposes of a case entirely, whereas administrative closure doesn't do that.
I don't think that necessarily helps you. It doesn't, the fact that it disposes of it make it even more clearly fall within this regulation, which refers to any action necessary or appropriate to dispose of a case?
Well, those regulations are not specifically addressed by the AG in matter of SOG. And he didn't need to address them because there are termination specific regulations. So to go off that, first, I would say that these arguments that petitioner raises about these general regulations weren't raised before the agency, and no court or the board has ever found a discretionary authority to terminate based on these regulations. In addition, matter of SOG has also never been considered by any circuit. So those beyond those things, there are specific regulations for termination, and the agency looked to those, as should this court and other judicial circuits, to look at the termination specific regulations. And we shouldn't ignore all those in favor of a general termination or a general regulation that wasn't addressed here. And we have these specific regulations. They say that immigration judges shall, and that shall make findings on inadmissibility, deportability. They shall direct removal or termination, such disposition. There's other termination specific regulations. And so when we're talking about termination, we should be looking to those specific regulations. And statutory and regulatory construction dictates that you're looking to specific. Specific governs the general. And that's exactly the situation we have. Petitioner would like to ignore all of this judicial precedent, all of these regulations, and essentially build off what happened in Castro-Tum, which is administrative closure and which is different. And it's also different if, again, for no other reason, we have nearly 50 years of agency precedent on these points about a lack of discretionary authority to terminate. The 9th, the 5th, and the 2nd have recognized this. And so we have these specific authorities, and these general authorities, the CFR 1003, they also say they have a limiting principle of consistent with statute and regulation with any other authorities. We have those authorities. And so that also plays a part in why there is no discretionary authority. We're not considering, this anew, or we're not looking at termination anew. It's set against this backdrop of the termination specific regulations of statutes requiring, with the use of shall, that immigration judges make these findings of removability, decide inadmissibility, deportability, decide whether they're removable. And this is all set against the backdrop of this other precedent, these other regulations, and you have to read 100310 as consistent with other authorities and statute and regulation, and that's what we have with this other precedent.
Counsel, can I give you a chance to I'm having trouble following why you think this is a Chevron case. Is it your understanding that what matter of SOG held was that the governing statutes would preclude allowing termination of a proceeding if the finding of removability has been substantiated?
So we understand.
Well, I guess maybe just sorry, go ahead.
No, please finish so I understand what you're asking correctly.
Well, is it your understanding that matter of SOG holds that there is some statute that would preclude the agency from giving immigration judges the authority to terminate proceedings if there hasn't been a finding that removability has not been substantiated?
Yes. So
okay, if that is your position, can you explain to me both how come we have a regulation that clearly says they can do this if there's a naturalization petition pending, at least under certain circumstances, and also why the Attorney General said in matter of Castro-Tum that if there's been a complete failure of notice, the appropriate thing would be for an immigration judge to terminate the proceedings. Are both of those things contrary to statute?
No, because
okay.
What we have is the general statute in 1229 that says that the immigration judge shall conduct proceedings for deciding inadmissibility and deportability, and then at the conclusion shall decide whether they're removable. Those are the broader statutes, and Congress, of course, hasn't directly spoken on how or when termination may occur. But we have these regulations that have been put forth, specific regulations that outline certain circumstances when termination would be appropriate. They were exercised within the authority of the Attorney General.
Yeah, but if they're, I understand that the Attorney General exercised his authority, both in writing matter of Castro-Tum and in promulgating the naturalization regulation. But if those are inconsistent, you just told me that there's a statutory command that IJs may not terminate proceedings unless they first hold that removability has not been substantiated. And I'm looking at two things the AG has done that are inconsistent with the statutory command you just described to me. And I am asking you, what is going on? Do we need to enjoin that regulation? Do we need to make, I mean, what do you want us to do here?
Well, first, this case isn't about administrative closure. So I think it's important to go back again, that termination is a different.
I'm talking about the
procedural
part,
posture.
I'm talking about the part of matter of Castro Toom that is about termination, where the Attorney General says, if there has been a failure of notice, you do not have authority to indefinitely close that proceeding. What you should do is terminate it.
Yes, and
So that's the part I'm talking about.
Okay, and if I let me go back a minute. If I misspoke and I said that the Attorney General, what he is saying is that in every case there has to be a finding of removability. When what the statute says is that the immigration judge has to conduct these proceedings on admissibility, and that they should be making a finding of removability, or if they're not removal or an admissibility, and then terminate accordingly. Where you have aliens who are removable, and DHS wishes to prosecute that, that is not a circumstance that is appropriate for an Attorney General's, for an immigration judge's discretionary authority to terminate. That has been held for years. So, and you have these general authority or this general regulation in 101.3, which opposing counsel raises. That's a general statute that the agency relied on for Castro Toom and administrative closure. We're in a different subset now, and that is general, but we also have these termination specific regulations, and that's what we look to in this case, along with the judicial precedent. This focus on these general regulations, these two general regulations that may have been appropriate in Castro Toom, because that's what was the basis for administrative closure, is not the sole basis for termination here in this case, or in any case of termination. We look to the statutes that require the inadmissibility and those things. We look to the termination specific statutes that the Attorney General has out, and we look to the case law, so, and the agency precedent. So the opposing counsel has put a lot of focus on these two general regulations to piggyback off of what happened in Castro Toom.
Okay.
But
so
these two regulations were
sorry,
not the source.
Counsel, I'm going to understand that you're not really making a Chevron or statutory argument. You're making a regulatory argument about the circumstances under which these regulations authorize IJ termination, right? Because now we're back to the regulations. We're not talking about the statute.
It's
no big deal. I'm just trying to figure out why Chevron is in this case.
So our primary
It doesn't
argument
matter.
here is that the way that the Attorney General set this out in the discussion is that he relies on, of course, 1103 for the authority, but also 1229A, which requires that immigration judges conduct proceedings and make a finding as to removability. And so based on that, and against this backdrop of the statutory obligation that immigration judges have to find removability, colors the immigration judge's decision on termination, and that there isn't this general authority, this discretionary authority to terminate, where you have, in light of the statutory obligation to determine removability, and in light of judicial precedent that has never allowed for termination on a general discretionary basis as immigration judges see fit, regardless of, removability, regardless
Counsel,
of if there's any eligibility for relief.
Sorry, Counsel, I keep interrupting, and I apologize. Before you are out of time, I wanted to ask you just a few questions about the continuance question in this case, if I can sort of take you into another area, and the sufficiency of the agency's explanation. And you say in your brief on page 34 that the agency provides these explanations, and there are 4 sites for the explanations. 2 of them are to the same form where the Attorney General, the IJ checks a box that says, let me see, the box says the motion is denied for failure to show good cause. You're not saying that that's the explanation, right?
Well, that was the conclusion.
Right, so that's not the explanation. Okay, so the one of them, so you cite that 2 times, and then you cite the part in the IJ hearing where she says, and I'm going to get this wrong, I denied the continuance because he doesn't have current relief. So he's seeking a continuance because he doesn't have current relief and he wants to try to get it. And the IJ says, I'm denying it because you don't have current relief. Is that an explanation?
So the immigration judge and then the board reviewed this de novo. So
no, I know, but I'm just asking, I'm just going through the explanations you
Yes,
cite in your brief.
Well, because he was seeking a continuance for relief that was speculative. And
well, that's not what she says. She says, no. I understand. I'm just going through the things in your brief that the IJ said. So she checks the box, and that is cited twice. The third citation is to where the IJ says, I'm denying it because you don't already have relief. And I'm asking you, is the government's position that it's cited in your brief, is that an adequate explanation for the denial of a continuance?
With due respect, we're looking to the board's decision.
Okay, so I'm going to take that as a no, and now we're down to the board. And the board says it's an indeterminate amount of time. But as to the continuance pending the mother's application, the evidence submitted by the petitioner says that the agency says this will be done in between 6 months and a year. And in fact, it is done in 6 months. And the explanation doesn't address that very important fact. When it says this is indeterminate, it does not address what seems to be a pretty important fact going to that. So why is that okay?
Well, the agency, in denying it, he had this more specific period of time. The agency, denied it based on these other things. But I would point to, as we know, petitioner's mom has now got her LPR status, and he has now submitted an application for cancellation of removal. But that was denied. So even if you give him the continuance, he got a second bite at the apple for his cancellation of removal, and he has not submitted any evidence going to prima facie eligibility, and the agency denied reopening on that basis. So even going to the continuance, or to some degree the administrative closure, he has now that opportunity for cancellation of removal. He submitted an application. He did not submit any evidence to go with that application showing prima facie eligibility. The agency was reasonable to deny it on that basis. And here now, before this court even, petitioner doesn't give any indication of what kind of evidence he's going to be bringing now to show that he is eligible and warrants cancellation of removal. So he has this second bite at the apple, and the continuance in the administrative closure, which largely sought for this cancellation of removal relief, and he's got that. He had that bite, and he still didn't bring forth what he needed to bring forth. So that, to some degree, continues to undermine the basis that he had for the continuance and the administrative closure. And I see I'm out of time.
Any further questions from the panel? No. All right, Mr. Winograd, you have 4 minutes in reply.
Thank you, Your Honor. The Attorney General, of course, relies mostly on what it views as favorable precedent. I would simply point out that none of the cases on which the Attorney General relies address Section 1003.10b or 1003.1d12, nor are they really accompanied by any substantive analysis. They're more akin to what the Supreme Court has described in other contexts as a drive-by jurisdictional rule. And I think those decisions really beg the question of why it is that IJs and the board can terminate proceedings in circumstances where it's uncontroversial that they have the authority to do so. One question that the Attorney General still has not answered is what gives the BIA the authority to terminate proceedings when DHS fails to sustain the charges? The only regulation on which the Attorney General relies is 8 CFR 1240.12c, but that only applies. Likewise, that we still haven't had an answer from the Attorney General about what an IJ should do when an alien is removable for having entered the country unlawfully. Status.
And I thought opposing counsel told me or gave me the impression that in the government's view, Cruz Valdez has nothing to do with what we're talking about today. What's your view of Cruz Valdez?
I would respectfully disagree. I think it undermines, the analysis in matter of SOG for the same reason that Judge Harris identified. But I think it also makes clear that if the court sends the case back for consideration of administrative closure, that my client would have a very realistic shot of having his request granted. And if I could move to the administrative closure issue, we think that that's another basis on which the court should grant the petition for review, because the board simply failed to consider that aspect of my client's request for administrative closure. There's no dispute that the board overlooked the request, and there's no dispute that the ordinary remedy under the ordinary remand rule is to send the case to the agency to consider a request in the first instance. The Attorney General, the only argument they raised in their brief was that a remand would be futile because the board would be unlikely to grant my client's request for administrative closure. But we find that argument perplexing because it's quite common for DACA recipients to have their cases administratively closed. We submitted with our opening brief 7 example cases in which the board had administratively closed proceedings against DACA recipients. And given matter of Cruz Valdez and the enforcement priorities of the current administration, it's quite possible that DHS would no longer oppose administrative closure if the case was remanded. So I think far from being the rare exception to the ordinary remand rule, this case is a quintessential example of when a court should allow an agency to address an issue in the first instance. And then finally, just getting to the continuance issue, as Judge Harris noted, the only reason the IJ provided for denying my client's request was that he was not presently eligible for any form of relief from removal. But that reasoning was nonsensical because my client had already been eligible for cancellation of removal. He would not have needed to request a continuance in the first place. And then finally, just to return to the question that Judge Harris asked at the close of my opening, I would say that if the court rules in our favor on the continuance argument and finds that the agency used its discretion in denying my client's request for a continuance, then it would not need to reach the separate argument relating to the motion to remand, because in that case, the case would have to be remanded back to the agency, and at a minimum, he would be entitled to a hearing on his application if his request for termination or administrative closure. If there are no further questions.
All right. Any questions? No. Panel doesn't have any. Thank you very much for your arguments, and we ordinarily come down and greet you if we were in Richmond, but since we're virtual, we can't do it. So let's accept this as a greeting from the 3 of us. Y'all have a nice day.
Thank you.
Thank you.
This honorable court stands adjourned until